In episode 64, titled Navigate Cloud Legal Duties and Shared Responsibilities, we frame cloud compliance as explicit contracts, clear evidence, and boundaries that are never left to assumption. Teams often believe the provider's brand equals compliance, but regulators and customers measure only what is written, configured, and provable. Our approach treats every claim as a commitment with artifacts behind it, every role as a named party with duties, and every control as something we can demonstrate on demand. By the end, you should be able to point at a clause, show the control that fulfills it, and hand over the record that proves it when it mattered.
The first move is to identify the laws and standards that actually bind your hosted data. Then map each obligation to specific cloud services you use. Data protection regimes and industry rules translate into named requirements such as lawful basis, access logging, encryption at rest, breach notice timing, and processor diligence. You convert those into service-level choices: which storage class, which logging stream, which key service, which archive, and which administrative boundary applies to each dataset. The mapping lives in plain language with the business owner's name and the regions in scope, so a reviewer can read it and immediately find the tenant, the controls, and the people responsible for keeping them true. Regulatory geography turns into configuration, not hope, when you require data residency, localization tags, and region controls that match the law. Each dataset carries a residency tag that constrains creation and replication to allowed regions, and backup and analytics jobs inherit those tags automatically. Cross-region services that ignore tags are either disabled for in-scope data or wrapped with explicit approvals that include legal review. Administrators see the region boundaries in their consoles, and requests that cross them are flagged for review with the regulatory citation attached. Over time, the friction moves to where it belongs, at the moment someone tries to place data outside the map the law allows. Contracts convert promises into enforceable duties, so you establish data processing agreements, DPAs, security addenda, and audit rights with measurable SLAs and remediation timelines. The DPA identifies roles, controller, and processor, lists subprocessors, and fixes where data lives and how it moves. The security addendum anchors minimum controls like encryption, logging export, and incident cooperation, while audit clauses state what reports you may request and how on-site or virtual reviews proceed. SLA remedies are written in outcomes a business can understand: time to restore, time to acknowledge incidents, time to correct a control failure, each paired with service credits or escalation terms. These papers are living instruments. You track their versions and who signed them because regulators will ask. Identity governance is often the quietest legal risk, so you document administrator roles, break glass access, and third-party support logins with approvals and expiry times. Every privileged role has a named business owner, an elevation path that uses short-lived credentials, and a record of when access was last used and for what. Break glass accounts are locked behind sealed processes and tested sparingly with an audit trail that proves the test was legitimate. External support access is narrowed to case-scoped windows, bound to named individuals, and captured in logs you own. This discipline turns powerful access into accountable access, which is what contracts and auditors expect you to demonstrate. Breach notification duties become muscle memory when you maintain contact trees, evidence expectations, and regulator timelines in a form people can actually use. Contacts list legal, security, privacy, and business leads with alternates, and they live where responders work, not in a forgotten binder. Evidence expectations describe which logs, approvals, tickets, and key operations you will preserve and how quickly you will export them. Timelines are written with clock times and local time zones, translating legal windows into absolute deadlines for your team. During drills, you practice these logistics, not just technical containment, so you learn how long your paperwork actually takes when hours count. Retention and deletion are legal obligations, not storage preferences, so you enforce guarantees using lifecycle policies and deletion verification artifacts. Each dataset carries a retention class that maps to a written rule and an automated policy that expires objects or snapshots on schedule. Deletions that fulfill a regulatory right are tracked by ticket with a pointer to the exact storage path, the job that performed the purge, and the confirmation event in your logs. Where providers offer delete markers or legal hold flags, you test and record their behavior so no one assumes they work the way a slide once suggested. The proof you keep is simple. Here is the request, here is the policy it invoked, here is the log that shows the deletion completed. Provider attestations help but never replace your controls, so you validate SOC reports, ISO certificates, and similar proofs. Then track exceptions and corrective actions. You note the reporting period, the scope, and the controls covered, and you align them to your own obligations to find what is not addressed. Exceptions in the reports become entries in your risk register with owners and dates, and you ask for remediation evidence or compensating safeguards when gaps touch your data. Attestations are treated as inputs to your program, not badges on a slide. They shape where you focus, but never excuse missing artifacts in your own estate. That posture keeps reliance proportionate and defensible. Privacy by design becomes operational when you run data protection impact assessments, DPIAs, and set minimal collection defaults in the cloud services you configure. The DPIA names the purpose, the data elements, the recipients, and the retention, and it identifies risks with concrete mitigations like pseudomization, shortened retention, or stronger access review cadence. In the tenant, defaults are set to collect the least necessary data, to disable features that expand collection without need, and to prevent broad sharing outside approved groups. Teams see the link between the assessment and the configuration, which matters when a regulator asks how you turned principles into settings. Over time, the habit is clear. Privacy lives in forms and in toggles, not just in statements. Several pitfalls are both common and avoidable, starting with ambiguous key ownership, cross-border transfers, and shadow SaaS. Ambiguous key ownership disappears when you specify who creates, rotates, and can use keys, and when every dataset states whether it uses customer-managed keys or provider-managed keys. Cross-border transfers stop being accidental when egress and replication are forced through region-enforcing policies that know the lawful destinations. Shadow SaaS shrinks when identity requires registration for app consent, when data loss prevention rules watch for uploads to unknown tenants, and when procurement is measured on reducing unvetted tools rather than only on cost. Each mitigation leaves a record policy file, approval report, and alert trend that proves the risk is under control. A concise scenario shows these controls in action when a regulator requests a data export and deletion with audit proof. The owner receives the request, cites the lawful basis and residency tags for the dataset, and uses a secure workflow to export the subject's records from the exact region where they live. The export carries a hash and a log pointer for integrity, and the recipient confirms receipt through a signed acknowledgement. A deletion ticket triggers lifecycle actions and immediate purges for data stores that cannot wait. Completion events from control plane and data plane logs are linked to the ticket. The file of record now contains the request, the legal analysis, the export details, the deletion confirmations, and the times that show deadlines were met. Because compliance must be demonstrable, you maintain an artifact set that proves it on demand and travels with the workload. Contracts and addenda live with version history and signatures. Attestations and certifications live with scope notes and exception tracking. DPIs live with mitigations and the configuration snapshots that implemented them. Logs include control plane, data plane, and identity events with trusted time, while tickets record approvals, break glass tests, export and deletion actions, and incident notifications. Reports summarize retention posture, key operations, access reviews, and residency coverage, and each report references the raw evidence you can hand over. This archive is not a museum. It is a working library your responders, auditors, and counsel use every quarter. To cement understanding, run a mini-review that connects each service model to concrete duties. For infrastructure as a service, you state that the customer patches hosts, hardens images, manages keys, and exports logs, while the provider maintains facilities and hypervisors and publishes platform attestations. For platform as a service, you state that the customer secures code, secrets, and configuration, and the provider patches runtimes and proves isolation. Monitoring is shared with clearly divided sources. For software as a service, you state that the customer governs identity, retention, and tenant features, and the provider runs the stack and provides tenant isolation evidence. Both share breach coordination duties.
Writing these lines beside each workload prevents the "we assumed they had it" moment that audits expose. We close with action that makes these duties durable. Direct a focused contract and attestation review for your top cloud services, listing gaps by clause and control, naming the owner and the date by which each will close. Capture missing DPA language, stale SOC periods, unclear key custody, or logging exports that do not reach your analysis within the agreed window. Record the decisions in the same library as your mappings and policies, and schedule one follow-up to verify that each fix produced the promised artifact. When this review finishes, you will have moved cloud compliance from assertion to evidence, and the next inquiry, internal or external, will meet a program that answers in receipts, not guesses. Thanks for listening. For more audio courses, daily newsletters, and more, please visit BareMetalCyber.com.